Hi guys, it's Kathy. I hope you're doing well. I hope you're nice and warm. Get under a nice blankie. We're fine here. We're 10 degrees, so we're not even below zero. We get below zero all the time, so this is fine. We're fine. The roads were a little icy yesterday, but we still drove. Oh, have to say hi to my Facebook people. I'm going to start my Facebook campaign soon, very soon, like within the next couple days. Trust. I just wanted to make sure it was all set up first. I know, Smurf. We're 10 degrees. Good. I'm glad you have your blanket and your pillow. All right, so we were on part five yesterday. We're going to finish the last of part five today and then move into part six. We're still going to be in January, though. Uh oh. Is the sound not synced? My coffee's almost done. I can hear it. If you tell me the sound's bad, I can fix it before I start. All right. I hope this works. I hope this works. Here we go. All right. Now, is the sound synced? Does it sound right or is it still wrong? Oh, wow, it's not? Okay, I don't want to do it if the sound's not synced. So, go make a sandwich. Give me 2 minutes. I might have to. Hopefully, this saves this stream. If it doesn't, I might have to start a new stream. But give me a few minutes and I'll fix it. All right, I'm back. Does that feel better? Is the sound better now or is it still wonky? I think it's better now. I'm gonna say it's better. Oh man. Let's see how bad the video is. I gotta open it again. Give me one more sec. Nope, that's wrong. That's part 7. It's like watching Bruce Lee sing Milli Vanilli. Let's see how the video is.
Through the process of toileting appropriately. Is that correct?
Yes.
Yeah. And are you aware of the fact, in your 30 years of experience and as a parent, that we very often potty train individuals who are experiencing toileting by using a pull-up and encouraging them to use the pull-up like underwear, go to the bathroom?
I'm aware of that
Okay.
approach.
So then the mere presence of a pull-up is not indicative of someone's refusal to attempt potty training with that child, is it?
I don't know if I see it like that.
Okay. Well, if it's
If
the
you want to
case,
restate that.
isn't it the case that a potty training regimen for whether for an individual with Down syndrome or a perfectly normal child could involve the use of pull-ups?
Could involve the use
Okay.
of pull-ups,
And
yes.
therefore, the use or the presence of pull-ups cannot be inferred to mean that Mr. Okapara is refusing to engage in toiletry.
That is correct.
Okay. Now, you indicated that you had reviewed, but you couldn't remember exactly which one, the child's IEP, correct? Current IEP.
I could, not in this moment, yeah.
Did you review that document, though?
The IEPs?
The current IEP?
Yes, I reviewed. I couldn't remember it all.
So then you're aware of the fact that that IEP indicates that the child is given 4 opportunities.
Yes, I did read that.
I'm sorry, can I finish my question?
Yeah.
Child is given 4 opportunities to use the restroom each school day. You're aware of that?
Yes,
You're aware of the fact that, and the IEP does similarly indicate that the child does wear pull-ups. You're aware of that as well?
yes, I am aware of that.
You're aware of the fact that within that same IEP, it still indicates that the child has an average of 2 changes needed per day.
Correct, I
So
read
that
that.
means that with 4 toileting breaks throughout the day, Aslan is still having an average of 2 incidents where she's soiling her undergarments.
Yes, I'm aware of that.
So it's not your testimony that somehow Aslan's aware whether she's soiling her undergarments, whether she's soiling a pull-up or soiling undies, are you?
I object
I
to
don't-
that. I don't know where he's going with this, like,
I don't know what you mean by that.
It's not
As
an
long as
objection.
she
That's
understands,
not
she
an-
can answer it, but if she doesn't, then you have
I
to
don't
clarify
understand
it
what
for her.
you're
Go
saying.
ahead and clarify.
You're also aware of the fact that the child, it's stated in the IEP, which, again, backing up a minute, you're aware the IEP is not generated by Mr. Okapari, correct?
The IEP is a team decision.
Right. He is not the one tasked with noting the observations of the school in this IEP, correct?
He is not noting the observations of the
Right.
school. That is the teacher's report.
Teachers, school
Nobody has ever asked me to talk faster before. Slower, yes, but never faster.
administrators, school nurses, correct?
No administrator, but school nurse may, not in the IEP generally speaking. The school administrators are in there. There's a facilitator, the teachers, and the school nurse if it's a health impaired eligibility.
And you're aware of the fact that in this same IEP, it's noted that Aslan has not yet gone a single day without an accident.
Yes,
Okay. And what I was indicating to you is, and I think it is a logical extension, it's not your testimony that somehow Aslan's aware when she's wearing a pull-up versus when she's wearing panties to soil one and not soil the other.
Yikes, Kay. I don't know if
not
it's a
that
pig.
simple.
There's nothing inherent in
I thought it was a
wearing
cat.
pull-up that encourages the soiling of undergarments, does
Hey.
it?
As a parent of a potty training with a pull-up, when my child was young, that's 30 years, they had pull-ups back then. And I would say that in my experience as a parent, yes, they know the difference. And they sometimes get lazy if there's a pull-up on because they know it's self-contained and it's held and nothing's gonna go on the
And that-
floor.
that's
So
based
that's
on
my opinion as a parent. That's not an expert
of your child.
of my kid and whatever other child I dealt with,
You
yes.
said as a parent. Though.
Yes, I will classify that as a parent's comment.
And forgive me, Is your child afflicted with Down syndrome?
No, my
Okay.
child is not.
Okay.
What, can I, do I get to ask questions?
Um,
Sorry.
Proceed.
Thank you, Your Honor. You indicated that as part of your work as a school nurse, you do developmental assessments.
Mm-hmm.
In your expert, in what I would vehemently object to being an expert analysis, but what you were, let me rephrase, what Ms. Hurd attempted to characterize as an expert analysis, you didn't actually perform any developmental assessment of Aslan, did you?
No, that is not
Okay.
my role.
And similarly, you didn't, while you testified that you perform physical assessments, you didn't do any of those on Aslan.
No, I didn't.
Okay.
She was not my case. No.
Right. And then you testified that the bulk of your experience with Aslan stemmed from a 6-week personal visit where she was with you in Colorado?
Yes.
And that was when she was 3, correct?
Yes, and
then
4.
and then a 4-week visit with you in Colorado.
Mm-hmm.
And these visits were of the species or character of friend time, social time with Ms. Hurd and
Correct.
Aslan. Okay. Not in any way
No,
in the context
no
of you
clinical, no.
nothing at all. And then I think you even indicated that they stayed at your house here in Henderson at the time?
Correct.
Right. Again, personal visit, correct?
No,
Did-
that was because they needed a place to stay.
Because they needed a place to stay.
Yes, with all the, I'll say it, drama.
All the drama.
Yeah,
At what time period was this?
I believe that was after this, I think it was around, gosh, September. And then I was back and forth to Colorado, so
I
they
don't
were there.
understand, you said this isn't personal. If you let people you know stay at your house to protect them from drama, et cetera, it's very.
19
personal. This wasn't
more.
a professional connection, right?
No,
You're helping them out. Okay,
Yeah.
I just wanted to
Yeah.
understand, because you tell them it's not personal.
no, I mean, it's personal in the way that I helped her
Okay.
out.
Sure, fair enough.
You also testified under Ms. Hurd's examination that your observations of Aslan's
Get a room.
enthusiasm in toileting, correct?
Mhm.
Okay. To be fair, the experience you were talking about was the total of the 3 times that you've seen Aslan in, let's say, the last 20 months. Is that correct?
Correct.
Correct. And one of those times I think you testified was a dinner party at your home.
I wouldn't call it a dinner party, but yes,
A dinner soiree, a gathering of individuals to
It
eat
just-
dinner.
not a gathering of a lot of individuals. It's Aslan, Kimberly, myself, and my husband, and it was more playtime with dinner, yes.
Playtime with dinner, okay. So then, not of the species of you there, again, with the clinical
So a dinner
hat on,
party.
endeavoring to analyze or make observations about Aslan's.
I can't separate my clinical hat of who I am as a nurse and a person. That's very hard to do. So when I look at a child, or I look at, just like you know, somebody asks you a question and you're an attorney, you can't step out of your shoes 100% of the time.
Sure.
I am who I am.
Oh no, that's not true. When I get home, I don't get nobody a drink. Nobody gets food from me, except for my dog. But that's different.
As a nurse and a person. So when I look at Aslan, yeah, I probably will observe differently than the average person.
Sure, but I don't give expert legal advice while I'm barbecuing though, and so similarly, I would assume.
I don't give expert legal advice either, or I don't give medical advice.
That's exactly my point, man, is
But
that- is that-
my eyes are trained.
And I'm gonna launch, Your Honor, if there's not a question posed, that I can just finish my question. So,
For sure.
so what I'm trying to attend to is that if you are socializing with Ms. Hurd at that dinner, correct?
Mm-hmm.
Socializing and playing with Aslan, correct?
Correct,
Socializing and spending an evening with your husband, correct?
correct,
Consuming food, correct?
yes,
Cooking food, correct?
yes,
Okay, so all
And
of those
beer.
other items that require brain focus and attention are absorbing some of your focus. So while, I would say, is it correct to say, while you may never be able to take the nurse hat all the way off, you're not actively in a clinical way acting as a nurse, much like I'm not actively
No.
acting. Thank you, that's all. He testified, and I'm not sure that I necessarily understood it, but it had to do with your general observations and opining regarding urine concentration.
yeah.
Remember that? Okay. To be fair, you're not medically certified.
No, I'm
so-
not, that,
Can
that's
I
fine.
please finish the question? Ma'am, I'm sorry, like I said, this isn't a personal thing, I'm just doing a job. You have no certifications, education, or clinical background in analyzing the concentration of urine, correct?
I have knowledge of it, yes.
But are you certified to perform the analysis?
I wasn't doing an analysis.
Are you certified to?
No, I'm not certified.
Did you, in fact, perform any analysis on?
No, there's no.
May please again,
Okay.
finish my question. Did you, in fact?
No. I'm sorry.
I know it's difficult, I know it is. Did you, in fact, perform any analysis of Aslan's urine?
No.
Okay, so then, there's a myriad of reasons that
Good.
one could have a rash, correct?
Yes.
And you were just merely opining on
Yeah.
some that it might be.
Yes.
Okay, but you didn't notably opine about sweat, for example, did you?
I didn't know.
Well, is sweat, is sweat and
I did
perspiration?
mention that, and I said that when kids get older, sometimes that will contribute to some of the rashes.
When they get older, but isn't it possible that that could be the case?
It could be.
Oh,
She's
okay.
older.
But notably, you didn't discuss that as what you believe to be the focus, correct?
I don't know if I really. I don't
In other words,
recall.
as we sit here today, you can't possibly offer a testimony as to what is causing the rashes on Aslan.
Correct.
And that's because both you didn't do any actual analysis, correct?
Correct.
Because you're not certified to do any
Correct.
such analysis, right?
Correct.
Okay. And just to be clear, so it's absolutely abundantly clear, you and Ms. Hurd are social friends.
I have a friendship with her and a mutual, yeah. What do you mean by social friends? Like,
Well,
I'm a friend to help, I'm a friend, yeah.
you're here to help,
What
is that correct?
well, yeah, I'm a friend. I mean, friends help, right?
When a friend asks for help, you help them. I would agree with you.
Okay.
I would agree with you in that regard. So, you and her are friends, and I'm meaning to differentiate that between, she didn't hire you professionally to perform an expert analysis of anything, correct?
Correct.
Okay. So the sum total of your testimony and observation here is based upon your 10-year friendship with Ms. Hurd, correct?
Yeah.
Your social.
He's making great points. However, the judge already knows all of this. He is wasting time. The judge understands. It's crystal clear that all of her testimony is bull.
Interactions with Ms. Hurd and Aslan,
Yes.
and your desire, as you said, when a friend needs help, you help them.
Correct.
Okay, nothing further, Judge.
Do you have any follow-up?
Yes, I do.
Sure.
We'll start right where you led off, the 10-year friendship. So you can testify then to my parenting skills and the type of parent I am.
Yes.
So. could
We
you
all
please-
can.
My observation
I would just interpose an objection, is her testimony now as a recipient witness, or are we still on the
The
expert?
court will make that its headache
I
later, as
understand, Judge, but
indicated,
since this is
but she
the
can
subject
ask
of
her.
one appeal, I'm just trying to make it as
Yeah, I
clear as I
understand.
can.
I mean, I can't certify someone as an expert when they themselves repeatedly say, I'm not an expert, I didn't perform I wasn't retained as an expert, I didn't perform an expert evaluation or issue a report or get certified or anything, I get it. But the court's, whether she'll have some findings of value as a precipient witness or a witness in some broader sense, the court will worry about that later.
Understood.
It's all,
I wonder what that means. I wonder what a winter storm in Florida means. Is there snow? I doubt it. There's no snow in Florida, is there?
better to have it in the record than not, if that's, so, and if it's eliminated, it's eliminated, if it's not, it's, then good, it's already there, so, you can proceed with your question, go ahead.
Going back, we'll start where you ended, and I'm gonna kind of work backwards again. The 10-year friendship. So you can testify specifically to my parenting style, my parenting skills, and what you've seen in my devotion, my commitment to both children, specifically Aslan because she is younger. What is your opinion based on my parenting style?
Objection, it's outside the scope, vehemently
I'm
outside the
gonna
scope.
allow, I'm gonna
I'm just
allow
gonna
her,
make it for the record, Judge, outside the scope of my
because
cross.
if this is, again, I get it.
Outside the scope.
If she's indicating she wants her as a more generic witness as to character or what, that's, or parenting, that's fine, the court will allow it. The court will worry about the admissibility of all this later and what's going on.
Just so I can get it on.
I
the
get
record.
it, she's asking her what her opinion of her parenting is.
It's just outside the scope of my
I get it.
cross-examination, that's all. And I
But
know
then
you know,
she's
Judge.
just,
it's
then
not-
she's just
this
gonna
is for
call
your
her
benefit.
later on her case and she for as a rebuttal or something, so what's the difference? Let's get it all out now. Go ahead. if you have an opinion.
Okay, so, when I met Kimberly, obviously, she had a son in high school, and so, you know, as a parent, and I watched her parent him, and then it was fabulous. She was very engaged.
How old is that youngster now?
He is in his 30s, and he's very successful.
Her son is in his 30s?
Hmm.
And he's very successful.
Yeah, but,
I thought she was in her 30s.
yeah, she looks it, doesn't she?
If nothing else, keep that
What's he,
together.
what does he do, what does the young man do for?
He's got his master's in healthcare administration, and he runs through Utah and other states and sets up doctors' offices and all kinds of stuff. And so, anyways, Kimberly jumped
I'll
on
take
board
it. I
as a
do not
healthy
mind.
parent with the baseball team, and I was actively involved in that, and that's kind of how the relationship began.
So
to
I'm an
got
involved
started.
parent.
Yes, very involved, more than any of the parents that I had worked with at the high school. So that was very appreciative, and that's probably why
How does
we
that
became,
portray
that's
the
probably
counselor?
why we became friendship, because I saw her level of devotion
Is that Bill? Bill is North Florida, right? Or is Bill South? Or in the middle? Where's Bill?
and dedication to the cause of her child being successful. Do I see those same things with Aslan, to have a special needs child? I'm overwhelmed at her devotion and dedication and resiliency in working with Aslan, as evidence of these court proceedings. She takes so much time and individualization with Aslan, and will take everything to the next level so it will benefit Aslan. So socially and educationally, and giving the opportunities for Aslan to grow and develop. Kimberly goes out of her way, from what I have seen in the time visits, as what I saw.
Since she was 3.
Mhm.
Okay, so thank you, I appreciate that. So going back to the urine analysis, that, you didn't analyze the urine.
No,
I don't know many people who notice rashes that take the diaper and go and analyze the urine. But you do work with special needs. You do work with children who can't even speak in special needs in your department.
yes.
And they're not speaking, autism. And what age have some of them been potty trained, as young as?
I have, in a special school, which is a locked facility, I have some kinders that are potty trained, and they're severely autism and nonverbal and combative.
And by what age were they?
I don't know, I don't have their folders, but there are, I have witnessed cases,
Right, by a young age,
young age, yeah,
younger than Aslan,
yes,
and they weren't speaking,
correct,
and they were developmentally far below where Aslan is right now.
yeah, yes.
Okay, that's fine, thank you. And as far as the rashes, while we're on that subject,
And Mr. Friedman's actually being quite gracious here. You think
Okay.
he's being contentious, but
then,
you're leading the witness, which ordinarily wouldn't be a big deal, but you're doing it to the point of,
okay,
you're
that's-
feeding her the answers.
okay, that's fine,
You can't say to some, right, I'm the most wonderful involved parent in the world, right, you can't do that.
right.
Now,
okay.
with the way this sits now, this witness, if this testimony survives, it'll be probably limited, if it does survive the record, as a character witness as to respondent's parenting, meaning that Mr. Friedman can recross on that aspect. We don't need any more about the expertise issue that's beaten to death. But since you're exploring this, he has the right to go down that route if
Okay.
if he's predisposed. But let her sing your praises if that's what the issue is. What do you think of me as a parent? Just
Right.
don't suggest the answers to her, because
Okay. So I'll
whether
give
he
you some
objects or not, and he's graciously backing off because
Okay,
he senses the court doesn't want this to devolve into a complete circus, and I appreciate that, but that said,
I
you
just have a couple
can't
more questions.
feed her
Okay.
the answers.
Okay, got it.
Thank you.
So, when he was talking to you about special needs are in pull-ups, and that is a process of training, as far as Aslan specifically, what is, let me see, okay, let me rephrase it, how long should a child be in pull-ups?
I don't know if there's
Depends on the
there-
child, doesn't it? Rephrase, please. It
Okay.
depends on the
Okay.
child.
How long should Aslan have been in pull-ups?
I don't know if there's a timeline for that one.
Is
It's,
5 years acceptable?
it just, honestly, I believe that it's just a training process and there's lots of pieces in it. So, except whether it's 5 years in a pull-up or not, it's just what are the pieces of a training process in order for her to be successful. It's not whether it's pull-ups or not pull-ups or underwear or this, it's what are the potty training process.
So, and when he was stating about the IEP, about saying how she was in her pull-ups, in your opinion of a good IEP, a well-written IEP, what is the parent's role in that IEP when it comes to toileting?
Well, for any parts of an IEP is you're there to advocate in the best interest of your child. And some of the better IEPs are written with the parents' vocal voice, and or involving the PEP, which is an organization that helps parents find their voice for the IEP in the educational system. But in terms of an IEP, you have to be an advocate for your child, and you have to get your child's best interests met in that IEP, and that's speaking up. And an opportunity, he made reference, the attorney, that there was 4 opportunities to use the restroom. That opportunities.
I don't remember using pull-ups at all. We used diapers and then we potty trained. I don't remember a time where we had pretend underwear. Maybe I did, but I really don't remember it.
It doesn't mean that the child is scheduled and coordinated and placed on that potty scheduling. So opportunities doesn't mean that she actually did it. Here, Aslan, do you have to go to the bathroom? A lot of kids will say no. Then they'll have an accident. I'm just throwing that out. I think there's better ways to word for potty training in an IEP than what was in that IEP.
So a parent's involvement in the IEP.
It's important, very important.
I didn't
Yeah.
use them, but I remember them.
A parent who's actively involved in advocating for their child, what would an IEP for toileting look like?
It would probably have a behavior plan in it in relation to toilet training with some goals and milestones and some specific targeted things.
For example,
So if she was dry for 2 hours in a pull-up, then she would put panties on. If she was able to successfully use the toilet 1 or 2 times during the school day, then she was allowed to pick from a treasure box. It can be a variety of ways to train
so
children.
necessarily not just affording her an opportunity to be
Opportunity.
in a pull-up all day.
Yes.
Is a success,
It's hard
in
to
your
measure.
opinion, a successful goal?
Yeah. Opportunity doesn't mean that the child is
Maybe
actually
if
doing
you really want, maybe you should bring at this point, we're just kind of meandering. Why don't you bring her back if you want, after he's on the stand, and then she can opine on what he said, whether, if she's accepted as some sort of expert on this issue, or if not, if her opinion's given any weight, and the court would have to make the findings why. And obviously, she's very knowledgeable in some areas and experience. She has, again, it comes back to, we don't know what he's gonna say, so against that backdrop, she'd probably rather address these questions after she can correlate what you say against what he says. And
We're missing Kelly and Fozzie. So is there power out in Texas somewhere? Or are they still good to go?
offer a viewpoint, I mean, so if you wanna bring her back later after you hear from him, that's fine,
I think that's fair.
But if that said, if you have more, cause the more time we spend on the potty training, it still comes back to, what is he doing? What is he doing? Is that unreasonable what he's doing? I don't, maybe he may take issue with some of this and he may agree with 70% of it, I don't know. He may be really open to things, at any rate, the court indicated, I may not be able to determine what's reasonable or not today unless it is established that this is an expert witness, which she herself says she's not in this area. And if I had such a clear record that he was violently opposed to everything she said after, or I would need something like that, but, so I'm gonna, again, it comes back to the beginning, I'm gonna send you both.
He's not alone.
Send you both to follow him. And I think a lot of problems have been caused by the fact you guys haven't been interfacing directly at appointments. But that said, if you want to continue,
I'd agree.
No, I would agree, and I agree with that, and I think that I think it'll be done.
okay, Mr. Friedman, based on that, do you have any follow-up on the
My understanding, Your Honor,
potty
from what-
training or what?
My understanding that your ruling was that you were not taking her testimony as expert on that, you were looking at. You
I'll
wanted
make
to
the
offer-
final ruling
wanted
on
me
that
to
later,
offer-
but the handwriting's on the wall.
I believe so, I believe it's clear under the law, but, you were wanting to know if I had cross relative to her, percipient observations of Ms. Hurd's
Sure.
parenting and character witness, I think is what you said, is that correct?
Character witnesses to parenting, plus if you do wanna pursue this potty training and juxtapose it with what he's doing or
I
not doing.
think
that's fine.
we have done about as much
I
as
agree,
we
I agree.
can with the potty training issue. You testified, and I don't wanna paraphrase, but to what an exemplary parent Ms. Hurd is, correct?
I don't know if I use that word, but
What word did you use?
I think resilient, and persistent and a strong and diligent, all those words.
You're aware,
Active, engaged.
active, engaged. You're aware of the fact that following the August 2022 decree entered by the court in this matter, that Ms. Hurd failed to appear for a single supervised visit?
Objection to that, because it goes further than that, objection.
Is this gonna be necessary?
Well, Your Honor, I can't.
Her opinions are her opinions, I'm kinda required to permit you to pursue this, but I
If
just
Your Honor
don't,
doesn't want me
let's
to-
not, let's
Yeah,
let's
you-
not go off the rails though. And
You can't let the mom just let this person sit on the stand who has nothing to do with nothing and say whatever she wants to say, and then stop him from the idiocy that he's going down.
then you have to follow up, if that were the case, would it change your opinion if that's where you're going on it? Okay, go ahead. Let's just get that, maybe it takes less time to
Your
go
Honor.
through it than me to get sidetracked with my concerns, just go ahead.
You know, if Your Honor's
Go ahead, no,
inclined to,
just
if
go
Your
ahead,
Honor's
go.
inclined to short circuit that area of testimony, I'm happy to withdraw the question, we can move
Okay.
on, Judge.
Perfect,
And whenever you decide to make a ruling as to whether,
Sure.
you know, she is an expert, I guess.
Sure.
and, you know, we can come back to that. I would also note, depending on whether she is or she isn't, the notion that Mr. Party would testify and she would sit in for that and then be recalled would be a problem under the exclusionary rules. So we
true,
kinda need to
true,
understand
on the
what's
other
going on.
hand, the irony is I wanna know, if she's gonna be recalled, I wanna know exactly what his viewpoint is, so I guess we could reproduce that from the representations to her when she's back on the stand, if she is.
Then, you know what, Your Honor, I would like to, as long as we're gonna do this, because the record needs to be clear, then I'm gonna ask some questions with Your Honor's permission.
Okay.
Okay, so, are you aware of the fact that, the dedicated mother you described from the period of August 2022
Mhm.
until April of 2023 did not see Aslan a single time? Are you aware of that?
Yeah, yes, I believe.
Are you aware of the fact that the reason that she didn't was because she refused to attend?
Objection.
I'll withdraw and rephrase.
You can ask her first, do you know, do you know why she didn't see her?
That's where it's going.
Okay,
Refuse was a strong word.
Yes, it is.
do you know why she didn't see her?
No, what I'm
Not
saying is-
refused, just didn't see her, if
Well,
that's,
well, you said you know she didn't see her, is that correct?
Yes.
Okay, and isn't it the case that she didn't see her because she did not attend the
Leading, that's leading, objection.
it's
cross-examination?
cross-examination though, so it's permitted, anyone can on cross-examination. Sort of on cross-examination, some people say always ask leading questions, on leading, never ask leading questions, so I don't agree with that in toto, but that's a good rule of thumb. So go ahead.
Because she did not attend any of the court-ordered supervised visitation settings, was the end of my question.
Yes, I'm aware of that conversation, yes.
I feel like either side can appeal this and win.
You also aware of the fact that, and this is in evidence at Exhibit 1, so I can take you to my Exhibit 1, but you may know, so I won't go there right away. You're aware of the fact that in October 29th, 2020, Ms. Hurd was placed under legal 2000 hold? You aware of that fact?
Objection, you'll have to show that. There
It's
is no
already,
legal.
it's
Is
already in
it,
evidence.
is it false, or?
It's already in evidence. It's in my trial binder, but it was admitted into
It's
evidence at
it's
trial.
a report, it's not a legal 2000.
It's,
But, I mean, it is cross-examination, but the questions have to
Brent, I disagree with you. Because he is an expert pottier. I know this.
be based on the actual record or
The record is in evidence.
I tend to think, I do recall, that, was there some distinction as to whether it was a legal 2000 or not, or some argument?
She was taken by paramedics for illegal 2000.
Does that
and
mean
it
it
is,
wasn't legal?
Sometimes people are removed and they're not necessarily held and officially designated as a legal
Okay.
2000, but if it was, it was. What document speaks
Are you-
to it?
we can turn to my binder.
Okay,
If
okay,
I can
okay.
approach the witness, Your
I'm
Honor.
not saying you're not right,
No, no, I
but she has an
understand. I can
objection,
approach.
so we have to, which number is it in your
It is
binder?
plaintiff's exhibit 1.
Oh, okay, that's perfect.
What number is it?
Number
Plaintiff's
1.
exhibit 1.
It's an incident report.
Beck, we love your picture.
Now,
Love it.
If it remains in dispute as to whether it's a legal 2000 or not, and the magic buzzwords are not used in the report, he's still permitted to explore, was she aware of this incident?
Yeah, this incident,
I
right.
can ask about the incident.
Right, and so what I think I'm going to do to make it most expedient is turn your attention to its plaintiffs P 2823.
Add exhibit.
Mhm.
So you're talking about this October 29th incident and the defendant's character for parenting.
3.5 years ago, but
Yeah.
We had testimony from when the child was 3.
it is, she was transported for a legal 2000 hold. The question will stand, whether or not the court provides us any weight.
Well,
3.5 years later would depend on whether how much things have improved, but if you're trying to just
I'm aware of
if you're trying to
something
just
like this.
focus on, would this shake the witness's opinion, you can, for that limited sake, you can pursue it. Go ahead.
I would take you to the start of the second paragraph of that document, which reads, while en route, dispatch advised that Kimberly was holding her 4-year-old daughter, Aslyn Opapari, and was refusing to let her go. Dispatch further advised Kimberly began running from the person reported later as Mr. Opapari. Upon arrival, made contact, South Boulder Highway, sitting on a curb. Mario had his arms around Kimberly, was crying, breathing heavily. Mario advised Kimberly, said, I do not want to live, multiple times, then ran towards Boulder Highway. Child in her arms.
She was not in.
Mario held Kimberly to prevent her from running into the roadway and harming herself in the presence of the party's child. I guess my question to you is, did that incident factor into your opinions on her stability and dedication as a parent?
Did you establish she knows about it?
She said that she was.
Oh,
I
okay.
know of something.
Okay.
I do not know this document, so in generalities in conversation, I knew there were some emotional issues going on. To the detail that this says, I'm not privy to that. Does it counter into my statements in regards to that, is she a good parent? Yeah, she is a good parent.
Okay.
I'll just flat out say that.
It wasn't to bear on, for the record, whether she was a good parent, just in terms of the dedication, consistency, because those are the things I think on.
It's a misstep, it's a definitely break,
Mhm.
and people overcome things,
Mhm.
and
Okay.
there we have it.
Okay. Just to move on briefly, you aware of the fact that during the period of time that Ms. Hurd was before this court, there were a myriad of instances, these are also in evidence already, myriad of instances where while parenting Aslyn, right, during the time she had her in her custody, she was repeatedly testing positive for drugs. You're aware of that?
Objection, there's only one
Okay.
report that says positive
There-
in
Since
Aslyn's
it's in
custody. Objection.
dispute, you can restate the question referring specifically
Okay.
to the month
I'll
and year
take you- I'll take you-
Yes,
given
the
test.
specific
Okay.
report.
I'll take you to plaintiff's exhibit 13 in our binder,
I just go to 13.
tab 13. Your Honor, this is in evidence already.
Okay, for the record, exhibit 13, collection of specimen back on and testing pretty much
This
around
was 11,
November
18,
18,
21.
2021
And
was the
this is-
collection of the specimen.
And this is when Ms. Hurd had custody and was actively parenting Aslyn. You're aware of that, correct?
Yes,
Okay.
she did talk about this to me.
And she advised you of this, okay. And you see this report here, don't you?
Yes,
And you indicated that you are, I believe you have is it a bachelor's or a master's in nursing?
I have a bachelor's and a master's in education.
So you don't have a nursing degree then?
I have a BSN, yes, I do.
Oh, I thought you said education, I apologize.
No, I have a master's in education.
Master's in education, bachelor's, science in nursing, is that correct?
Mm-hmm,
Okay, all right, so fair to say,
and a bachelor's in social work.
okay. And so then, you note here that as of November 18th, 2021, while actively parenting Ashley.
And she sells Avon.
Ms. Hurd was positive for barbiturates, methamphetamine, and amphetamine.
Yes, I see that.
Right. I'll next take you please to exhibit 15.
I'm sorry, 15 or 50?
15, also in
Thank you.
evidence. Are you there?
Mm-hmm, I'm there.
Now you'll note that the date of this task is March 7th, 2022, correct?
Yes,
Okay. Now, are you aware of the fact that this is the time period wherein she was zealously advocating, and in fact, zealously advocating for Aslan to be in her primary custody? Are you aware of that fact?
correct, yep.
And you're also aware of the fact that this is a period of time that she believed that she should have had Aslan in her primary custody, right? You're aware of that? Okay. I'll withdraw the question.
These are leading, I didn't have her in my custody, so where are you going with this?
He said,
I need to find someone who sells Mary Kay. Remember that stuff they had? It was like a 3-part system. Skin So Soft, was it? Silky hands, satin hands. What was it? Their Skin So Soft was Avon. Mary Kay had this satin hands or whatever. I need some of that. So if any of you are selling Mary Kay, let me know.
said you were
Did you want me
advocating,
to
he
do
said you
search
were,
for
he,
her?
no, he said you were advocating at that time
Okay,
for her to
I'm
be in your
advocating for
custody.
okay.
Okay, go ahead.
And you'll note that the time that this specimen was collected, it's March 7th, 2022 at 12:31 p.m., correct?
Mm-hmm,
And at that point in time, she is positive for both alcohol and another barbiturate, bolitabol.
Objection, I have testimony and
Your
I have,
Honor.
that is my.
That's not
And you'll be permitted to address it, but he can
Okay.
bring to
It's
the
in
attention
evidence.
of the witness whether the witness is aware of
Okay,
these
but they're prescriptions,
toxicology
and a UAC
reports.
is different than a BAC.
The witness will react to it as
Okay.
she sees fit. If she doesn't believe in the characterization of the questions, or it doesn't change her opinion, or she's questioning what it shows, she has that ability.
this conversation I did have,
Okay.
I was aware of this. I've not seen the document, but I was aware of this through conversation with Kimberly.
Aware that she was
That she
actively
described this, yes.
testing positive
She
for
was very
alcohol.
honest, yes.
You aware of the fact, and you may not be, but are you aware of the fact that during that period of time, the court had ordered that she refrain from all substance use?
No, that,
Court,
I have to
I'm-
assume
I'm-
that, I have to assume that that
there's
was
no
the
order
order.
of that, there's no order of that.
So the court said it was okay?
The court didn't say specific order not to do prescription, my prescription
Oh,
medication.
well, yeah,
not to
yeah,
have
I
drinks.
get
It
that,
said
I
no
get that
illegal
part, but
substance.
we
There
have.
is no illegal substance.
Is that a
which
bad
one,
thing?
15 or 14?
I'm 15. There's no
15 or
illegal substance, it's my prescription,
Your
and there
Honor.
was no alcohol concerns at the time, that was not in an
No,
order.
no.
Your Honor, what's being argued, I don't know why we're arguing for a question.
If it
What's being
works, it
argued is
works.
that after testing positive for illegal barbiturates and methamphetamine.
It's not illegal, that's my prescription.
Methamphetamine is not illegal?
Okay,
That was
well, that's
initially-
number 14,
I
that's not
understand,
showing in
but the argument-
We're
15,
at
but
16 with
this,
butalbital, butalbital is part of my
this
hearsay.
witness is able to look at what it says.
I did see it.
She knows, and, you know, for the sake of this, just so everyone knows, I make it abundantly clear, if somehow
I wish I could give you all a microphone right now because apparently what we're doing today, anybody can just talk whenever they want to.
it's not in this record, that's my bad, but 98% of the time, I hammer on these things and say, declare every prescription you have when you're in there and determine the
We know what
dosage amount
Brute
and the
is.
civil
Right, that's
amount.
gonna
Because
be-
otherwise, if it appears and you didn't declare it,
And
it
that's
would be
a point of
assumed that, it
contention
would be
because I
assumed
did
that
and they didn't
it wasn't
report it.
prescribed and that it's
That's-
used rather than abuse. I'm not saying it is, I'm
Yeah,
just saying.
that's an issue that we're
Let's
gonna
not
have.
Okay,
get
so
to-
let me just
look,
say,
and with the
I'm aware-
With the understanding that your position, and it doesn't seem to be controverted, that you've been clean for many months, I don't think you should be spending a lot of time worrying about this, but that's just,
All right,
you know,
okay.
I'm just trying to save a little time. If it's important for him to, okay, you've seen this one.
Yeah,
Okay,
she
all
was
right.
forthcoming and honest about it, yes.
All right,
I like Bud bud perfume.
I mean, if the witness doesn't change her opinions of the parenting based on any of this, that's something you can comment on later. Her opinions are her
And
opinions.
that's the point of my question, Your
Alright.
Honor, and with that,
Alright.
I have nothing further for the
All
witness.
right, did you have follow-up or?
Alright, I'll sure, I'll, since now you've seen the reports,
Mhm.
and you're see what there, and your opinion is not changing of me, why is it not changing?
Well, since the reports, you have been diligent and have been fighting for your rights with your child and have dug in deep to, in your opinion, do what's best for Aslan. And I, as a person,
But
respect that.
how, why is your opinion of me specifically, not what I'm doing with Aslan, your opinion about my parenting and who I am, why is that not changing? No, now they've shown you these positive labs, they've shown you the methamphetamine, why is it not changing?
Because it was a moment in time, and people overcome bad steps. That's just life.
And in your opinion, did I?
It was,
Can we
You-
short circuit this?
yes,
Are you trying to say if she was on drugs, she's not now?
yeah,
Okay,
that's pretty simple.
all right.
She's overcome.
Thank you.
Come on. Do you have additional material for the witness?
That's you, right?
No, no, it's back, it's.
Yeah, I was wondering if you had any.
Oh, okay,
additional-
sorry, I
Oh,
didn't.
no
know.
problem.
No.
Is the witness subject to recall later?
Monica, lower your
Presumably
blood
not.
pressure.
We'll find that out later. Did you have anything additional of this witness?
No recross from Ms. Hurd's last.
Oh, okay.
question. No,
And
no
so
recross.
neither of you have anything additional, or do,
Well,
you're more than invited if you have anything
Okay,
additional.
then I will, I thought,
All
okay,
right.
I misunderstood.
No.
So if we're gonna go ahead and look at, evidence, let's go ahead and go to my binder. It's right here, they're right here, they haven't been handed out.
Okay, we have it.
So there's one that says witness. Can I read it, Mr. Friedman?
Do you want me to just put this on the side?
I would just,
Yeah. Oh, wait, do you
Yeah.
guys get your binders? There's a lot of them.
I know.
Oh, okay, it says it on there. Okay.
just as a general housekeeping judge, I'm fully unaware of what's in Ms. Hurd's binders. I don't have them. I was never provided one, so this will be the first time I'm seeing it.
They were provided yesterday, he could have taken it with him yesterday. He knew they were here, and I was told to bring them here, which I did, and it's in an email.
Yeah, but I can't require someone, well, you have to read this at night at 8 or 9 or 10, so try and get, if you guys have material, try and get it to each other, okay, early. What is it, which exhibit do you question the witness? Which exhibit?
I'm getting there.
Okay.
I don't know.
Yes, I'm
Alright,
sorry?
So if you wanna go to my exhibit,
Mm-hmm.
Oh, yeah, of course.
let's do this first.
Okay, well, in recess for 2 minutes while the clerk has to switch over.
Right now?
Understood. Thank you, Judge.
just right now.
Okay, that's fine. Yeah.
Thank you.
the record.
Okay, we're back on the record. Let's proceed.
Alright, since we're,
I know Your Honor is disinclined to apply these rules, but I would just note for the record that the rules would provide that the questions that she asked would be within the scope of my recross. I'm just making
There's
that
been so much
observation.
back and forth that I don't know anymore.
and that,
What, but I don't
I'll
think
clarify
I
that.
don't
So
think
that
she had
was-
much left, or maybe you did. Were you questioning her about the legal 2000 or the what?
right, so he was asking questions regarding my labs, right? So can I, am I
Yeah.
allowed to?
Yes, yes.
Okay, so I was just gonna point out a lab. So BB,
Okay, B.
the double B, exhibit BB,
All right, I'm looking.
And then just for the record, none of these are in evidence, correct?
not yet.
Okay, well, so just want to make
So
that
then
very
can-
clear.
Lab results.
Well, I want to make it very clear that nothing in her binder is in evidence, Your Honor.
How many of these, well, I think the concern here is, were some of these on her own initiative but not court ordered? Because there's an awful lot of them. Is
Yeah.
that the concern, that you're not sure about the integrity of some of
concern
them?
is simply that what I was referencing, Judge,
Yeah,
were exhibits that were already admitted into evidence.
right.
I don't know
Right.
that you're looking at, but what is attempting to being discussed right now would be a proffered exhibit.
Right, but is the concern that, I think, if I understand the concern
I'm gonna have a
correctly,
myriad of
there's
concerns.
a series of drug tests that you're concerned about, A, that they weren't court ordered, and B, that they may just be urine and not full hair follicle screening.
The judge is not allowed to look at this. Why is he looking at that? He is not allowed to see these things. Is this like a real court? Is someone pulling my leg now?
Not foundation, this isn't the proper witness to authenticate them, they're not in evidence, they can't be discussed.
You know,
That's true.
that's fine, we can,
Okay, we'll move on. So you did test, some of these tests are on your own initiative, I take.
yeah, and they
Okay.
are hair.
Okay, that's all.
I have 2 hairs.
Okay.
Move to strike, Judge.
Okay,
You can't
understood.
testify
There-
about-
No one's seeking to have them admitted now, and if
Okay.
drugs is gonna be, the backdrop of narcotics is important in the sense of how we got here, or historical rulings, but.
What is it
for the-
called?
To the extent that we're proactively going forward, when the emphasis is there, then it's a matter of someone clean as of this time, and have they maintained that for a comfortable level of time. So let's move on. I understand what's been presented.
Okay,
Okay.
Okay.
Okay. Okay, so, but that, you can still question this witness about anything you're aware of that you want.
I think with the whole,
Pardon?
I think with the last question, I kind of covered.
It appears to be the
Yeah,
case unless there's something
yeah.
else. Okay. Thank you
Okay,
so
so
much for your-
I put
oh,
that
I'm
there,
sorry.
I'm
Did
good?
you have anything further?
Oh, no.
Okay, thank you so much for your testimony.
Yes, thank you so much.
Who would be our next, witness? Who would our next witness be?
I guess then we call me, Mario. She was the main one that I wanted, and I'm gonna be real honest, I don't know how these proceedings work and operate, so this is my first one. I am sorry, and I apologize to the court, it has to deal with, my ignorance of representing myself, but this is what I'm been forced to do, and I'm making the best of it that I absolutely can.
I think what might be best in these situations is it would be ludicrous for you to ask yourself, I've seen people do it, Q&A, ask themselves a series of
Thank you,
questions
Anthony.
and then answer it. I think it would be better, and you'd have to take the stand for it if you're offering your own testimony, you would make a statement to the effect of where you think we should go from here as to what's in her, Aslan's best interest, what schedule you believe should be implemented and why. And then Mr. Friedman would treat that as testimony and have the ability to examine you based on that. And then with his client, it's simpler because he's represented, he'll ask him questions and then you can cross-examine. So if you both, did they both raise their hands to be sworn yesterday? Did we get them sworn in yesterday?
Yeah.
We did?
No.
Oh, let's go ahead and take care of that, both please raise
Please,
your hand. to
both
be
parties
sworn in.
stand, raise your right hands, the clerk of the court will swear you in at this time.
You and each of you do solemnly affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
You're such a good dad
Thank you so much.
to your doggy.
Very good. So, if you wish on your case, you can call him. You don't have to wait for them to do that direct. You can call him on your case in chief, and it's sort of direct. Technically, it's not cross-examination, but since he's an adverse witness, it's controlled by the same.
She was having issues charging her iPad, so maybe she can't get it charged.
Rules, you couldn't ask him leading questions, etc. You could call him, and then Mr. Friedman can question him based on that, and then recall him on his case as to any issues you didn't address, however you want to handle it. Or you can go first with your statement as to where we should go from here, and then he can question you based on that. But if it's testimony, it really shouldn't be argument. Argument or what's wrong with the record, or what should be done, or what was done wrong, or something, is saved for closing arguments. Testimony would be to the point of where do we go from here, and to address, in other words, it has to surround parenting concerns. It has to be about that, not all these procedural, legal, and other issues. That can wait for closing argument or briefing if you guys want to brief. So with that said, did you wanna make a statement as to the parenting history and where we should go from here, and then he can question you on that, or do you wanna call him first and have questions for him, or what?
So if I call him, am I allowed to present my own evidence yet, or?
You could still make a statement, yes, as testimony later, it just it would be later instead of now. You can do whatever sequence you want.
If I can, I think, were you asking if you could introduce evidence? And
Right.
I believe, Judge, that's
Yeah.
your question,
Yes.
could she introduce evidence if Mario's on the stand?
Right,
Or try
right,
to?
sure.
Can't.
I,
Oh, yeah, that,
And
I
that,
think
the-
in legal
obviously,
okay,
the
that's-
most
that was my
difficult
question.
cases by
So-
far for the court to struggle with, all cases are difficult, but cases with two attorneys or two people unrepresented are difficult, but by far the most difficult is one's represented and the other isn't. It's really frustrating
I
for the
know,
court.
but it is-
I love subscriptions. I don't have any right now, but my favorite subscription ever that I had was Loot Crate. It was awesome. I love Loot Crate.
And for everyone else, so how do you wanna handle it?
So, that was my question, can I introduce into evidence some
Look,
of
if
my?
you show him documents and you want those admitted to evidence and the foundation's established, he looks at it, yeah, I'm aware of it or whatever, or you do it through your own if he's unaware of it, you can do it through your own testimony.
Okay, yeah, if we could,
Would you rather him on the stand now and you question him, or did you wanna make a statement and then have Mr. Friedman question you?
I guess, I'm sorry, I'm,
No way, I'm not
If-
giving
if
them
I-
out. It was all
If I
mine.
thought one method was that in your best interest more than the other, I'd guide you on that. I don't necessarily have an opinion on that, because eventually it's
too
all
much.
gonna come out anyway, whether it's in this, just the sequence is what's important.
okay, then can we call him?
Okay, and unfortunately, we will need a third day on this. I'm gonna start looking. Okay, so,
Please, and
because
once you
yesterday
step
was
here,
eaten up with attempts at settlement
the
negotiations.
parties
so-
have been sworn.
Your Honor,
Parties
again,
entitled
I
to
would just renew the inquiry I made of the court earlier. I now see that both the witness that was formerly on the stand as well as Ms. Hurd's mother at the end of the courtroom.
True, but her grandma has always been here, and
Okay, but is she going
the
to be a
findings will
witness?
be made on that one way, I get it, that needs to be on the record when she testifies. As far as our last witness, I didn't believe she was subject to recall, but if she is, and then that's gonna be an issue we'll deal with, that she heard the testimony.
Your Honor, forgive me if I'm misinterpreting the exclusionary rule, but I don't know.
But the intent of this isn't some
Lawyer, take everything you learned in law school and throw it away, because that is not appropriate in this courtroom. That is outrageous.
someone is in the courtroom, so automatically everything they say is discredited. However, it does indicate if it can be demonstrated that a person was likely to have been influenced or manipulate answers based on that, and often that argument is made and it's established.
So then,
They've
Your
been
Honor,
here so long, it's done, it's there. If either of them get called
Probably.
later, we will cross that bridge now. It's gonna compound problems if the court, it makes it worse if the court excludes them after they've been here for 80% of it. I'd rather just have the full-blown problem and deal with it rather than someone being able to say, look, you tried to remedy what couldn't be remedied right near the finish line. So just let it go. I'm not even sure. I don't assume either of them will be, if they are, we'll deal with it, okay? And that'll be right on the record. And sometimes it's a sound argument. Well, you heard this testimony, Judge, obviously, this sounds like it was manipulated by what was heard. Okay, so let's proceed then. Okay.
All right, so plaintiff's exhibit 46.
I'm sorry, Mario, this is not my show, this is Ms. Hurd's show.
Do I need
Yay,
to-
6
plaintiff's
months. You got a
exhibit
gold
46,
star.
the binders,
Good job.
Binder 404.
You're working off, just to be clear,
46.
our exhibit?
Mark,
Submitted by my
It's a mark to 25,
The
is there a
only
book that
exhibits-
takes us to
if- let me be
46?
clear, housekeeping, the only exhibits from my binder that were in evidence from the prior trial are 1 through 30.
Yeah,
Anything beyond my number 30 is not in evidence unless it can be admitted. Now,
Right.
certainly, there are many of them I intend or may
Okay.
intend to introduce, but what I was working off of were exhibits already in evidence from the previous trial.
if you have something that's not in evidence at the previous trial, but you have it at your ready, just show it to them and maybe you can
Okay.
establish.
So it was the talking parents record.
What number?
If you go to your 2560,
What number in the
We're in
binder?
exhibit 46.
that's what it says here now.
Mr. Freeman, take a look at what she has. see if it-
They're my exhibits, Judge, so
Right,
I'm
but-
aware. And,
Well, true,
uh,
but you may not.
I can streamline this, Your Honor. These are absolutely a complete message record
Okay.
from talking parents. There is
Perfect.
no admissibility issue. If we'd like-
Perfect, if 46 is admitted, you can ask them whatever you want within reason.
Okay.
Go ahead.
Alright.
Drunken Smurf, go to bed.
Alright, so
Quit fighting it.
2560.
Drunken Smurf, listen to
And
CJ
we'll
read
be
to you.
starting about
You'll
halfway
fall
down
right to
the
sleep.
page, With the date of, actually the whole page, from 2560 to 2566. You review those pages,
I'm sorry, what are the page numbers?
2560
Mm-hmm.
to 2566. And these are messages from you, correct?
Yes.
Okay. And they're messages to, who would they be to?
By the way, what are the dates of these?
Oh, so this would be from, August, well, from the very top it says August 3rd.
He's not going to bed yet. Didn't you see that?
Last
He
year?
said no.
August 3rd, 2022
Okay,
to, January.
of 23, okay.
No, to July 18th of
Oh.
2023.
Yeah, about a year span,
Yes.
okay.
Yeah.
All right.
So, and these messages that you're writing, are to who?
You?
Okay, and were you aware that I was no longer on the app and nor, was not ordered by the court to be on this app? Okay,
Do you understand the question?
No, I do not.
Okay, break it down, please.
you are aware that I did not have this application?
I wasn't aware.
You were not aware?
It's what you were said, but I was aware you still had it.
Okay, so what is, if you go to page, oh, let's just go to the very first page of that same exhibit. So that's gonna be 2455. At the top, it says a complete message record with who in Mario Okaperi? What's the name?
I'm trying to find the page.
Stitches get stitches.
No longer a user.
Correct, so it's not my name. The name does not say Kimberly Joy Hurd.
Correct.
Okay, but admitted into evidence already through Ms. Chrome's evidence. And that's going to be, this is what's already admitted into evidence, that's what we're going off of here. Number 13,
Is it in your exhibit book here?
it's not in mine, this is already admitted into
Is it in
evidence,
mine?
so.
Well, I don't have it in mind, so I don't.
So do I need to resubmit evidence that's already been submitted?
Well,
I don't know,
if you wanna use it as-
did we even have 46 up here? Yeah, we don't have 46, but it's all right, go ahead. You can establish what it says and
Okay.
we'll go
Well,
from
so,
there.
and Ms. Cromes, at the trial on August 16th, 2022, she admitted into evidence, and it's admitted into evidence, number 13, the same record, and at the top, I would need him to say it, it clearly shows the name, Kimberly Hurd and Mario Openberry.
Okay, do you see it at the top there?
It's not here, Judge, it's right, objection moved to strike, she's testifying.
So it's
I'm not-
already admitted
I'm
into
not-
evidence.
Okay, but is he
Let me
looking,
clear
is he
my
looking,
objection.
yeah.
I'm not
Again,
disputing
is he
that
looking
there
at,
were
is he
56
looking at number 46?
But she took, number 46, yes, he was looking at. The document.
What do you
she's-
want, okay, which one do you want him to look at right now as we
So,
speak?
right, so what
Because
I'm
he
referring
can't
to-
see that part that
Okay.
makes the reference you just said, so
So he
direct him
stated,
to it.
the witness stated that he didn't know that I wasn't on the application anymore. And that's what I'm trying to establish,
Right,
is
but
that
if
he
you
didn't know.
discredit him based on that just make sure he's looking at the same paper you are. If you wanna show it to him, cause it's not in front of him, that's
Okay,
fine.
so, okay, it's already admitted, so,
Yeah, but he may not be looking at it.
okay,
Is he looking at it?
so do I need to show you?
Go ahead, show it to him.
And can you read the name up there?
Kimberly Hurd,
And,
Mario Oakberry.
Drunken, no, that's too low.
so when you see the name, no longer a user, does that indicate that maybe I'm not a user anymore?
No, because that paper was printed August 3rd of 2022,
What paper?
the one you just showed me,
Okay, so you knew that right off the top.
because it's on the bottom of the sheet.
Well, let me, was the offer of proof or purpose?
I
of it?
totally
You
hate
never
those
received
type
this
of people.
material, so you're saying you never received it?
I was not on Talking Parents, it was not ordered by
So
the board.
you weren't involved in these communications?
No, I'm not, and that's what I'm trying to establish.
All right.
He had, okay, so from,
So these are just communications from him that you didn't
I
receive
never
or respond
received,
to?
he
Okay.
was, so, yeah. So,
Your Honor, they're received.
Mr.
they were
Opari,
not
The
received.
messages say red
Mr.
when they
Mr.
are opened.
Opari, we will address this on redirect, it's fine. It's a bit
Okay.
confusing, but we'll,
So-
don't worry about it.
When they are received at the bottom, okay, let's go to, we'll do it now. Okay, 2560. When a message, let's start from the top. What does it say? August 3rd, 2022. What does your message say?
I'm finding the page, hold on please. On 2560,
Correct.
says here,
All right. And then, what is there something attached to that message?
yes,
Okay. And then the next message down says,
another copy,
okay. And then there's something attached?
yes.
Okay. Right below that, what does it say?
No longer a user viewed this subject,
On?
8/4/2022.
Okay. And what does it have that indicates when I view it? What's the icon?
An eyeball, it looks like?
Okay. So that, would you agree, shows when I view one of your messages?
Yes.
Okay. So as of that date, I viewed the application. So now let's go down to,
So the purpose of this, you never received any of this?
I'm going to establish for the last year, he hasn't communicated with me. He's communicated with me via app I don't have anymore.
So you never received it? Okay.
Right.
All right.
So, August 4th, 2022.
So you never responded to any of this?
You're asking her, Judge.
Yeah,
I've
there's no
sent, I've sent
conversation,
him, I've
it's
sent
all,
him
it's,
messages via text messages, which they're not admitted into evidence,
right,
so
I
I
get
have to
that,
wait. But he was responding to those text message via an app I never saw. And
Okay.
I can prove I never saw it because he
so
will,
this will be a lot of communications from him where there's no responses?
this will be a lot of communications from him responding to me in an app I don't have. So his form of communication with me for the last year,
So are you, is this just all his communications or are you responding?
I didn't even know. I didn't know he was using this. I told him I didn't have the application more. I was using text messages and emails and letters to Mr. Friedman.
So then all these communications should just be him with no response from you?
Right, he's
Okay.
saying that I'm viewing them, I'm trying to show that I didn't view them.
So none of these are purported to be from you, they're all him just
Right.
arguing with himself for a couple of years or what?
Yes, exactly, that's what I'm trying to establish right now. I know,
Okay.
it's crazy, so. Okay, August 4th, 2022. You sent a message, correct?
Yes.
August sixth, 2022, you send a message, correct?
Yes,
And we can keep going down the page to the bottom. We get down to the bottom, September 17th, 2022. You send a message, right?
yes,
Okay, between the dates of August 4th, 2022 to September 17th, 2022, did no longer a user view any of those subjects?
no.
Boy, is that a loaded question. So, here's what happened. So, 2 years ago, 3 years ago, in 2021, they suggested this Talking Parents app. And they were both on Talking Parents together. And they had issues. But the court never actually put it in an order. And 2 years ago, they brought it up again because there were issues. And the court never actually put it in the order. And she's saying, well, the court didn't order it. And the lawyer is saying, yeah, well, the judge said we should do this. And the judge said, I shouldn't have to order this. This is helping you to communicate. Normal people would just use it. But again, he didn't put it in an order. And he even said he wasn't going to put it in an order. And we knew that was going to come back to bite him in the ass. And it came back to bite him in the ass because she's not using it.
Next page, page 2561. At the top is a message from you on September 19th, 2022. Can you read that?
Here are some photos of Aslan.
And how many photos or attachments are there?
4.
4, okay. What's the next, September 19th, 2022. Can you read that one?
Aslan lost her first tooth today.
And attachments?
There's 2 of them.
Okay. Let's go down all the way to the end. October 23rd, 2022. Can you read that message?
I said again, you can just not FaceTime and you can see Aslan at Family First on Tuesdays and Thursdays from 6 to 8.
And that whole page, did no longer a user ever view any of your messages?
No.
Next page. On the top is a message, October 27th, 2022. From you, correct?
Yes.
Okay. We'll go down a few. November 1st, 2022.
Get it. Why are you sending messages month after month if it appears they're not being received or viewed, or you don't have the correct connection to her or whatever?
Why are you
Because
yelling
this
at the
was
dad?
after our trial in August and the court ordered.
It's
to
her
stop
fault.
Parents.
Fair enough, but the order is not a hyper-technical one. It means it's not just to comply for the sake of complying, but to facilitate communication. If, and I don't know if this is valid at all, if this is true, you had an affirmative obligation to point out to Mr. Friedman the obvious. I'm talking to the brick wall here. I keep sending messages. Something's changed. She either declined them or she changed it all. Let's get this correct. He would have shot a letter off to her or some indicating, what, do you want to receive these communications because you've terminated this service or something? I mean, I want everyone to understand, comply with the spirit of orders, not just the orders such as, this is to help and facilitate communication. So if one or both of you communicates for months and months and the other seems to have love.
Sometimes I wish I had a standing order. I don't know how I did it. I used to sit at a desk for 12, 14 hours a day and write code. But now that I'm serving, sitting here at this chair for 4 hours is hard. I want to stand up. My back gets all stiff. My daughter bought me one of those heat and massage things you put on the chair. So I put it on the other day, and I was sitting way close. I was falling off the chair, and it was real loud. And I couldn't even imagine pushing the button while I was in a live stream. That would have been so funny. I should have done it. That would have been hilarious.
Logged off or selected some other modality or something, and they're not receiving it, bring it, and like you represent, bring it to your attorney's attention, and,
Your Honor,
well, never mind. I mean, so I'm a little confused. You're saying that he communicated for months and months,
For a
knowing
year,
that
over a year.
knowing that he wouldn't receive an answer and that you couldn't answer because you were oblivious to it?
Correct.
Okay,
And I mean, this would be my testimony, so I can't say
all
it
right,
right now.
no,
Okay,
yeah,
so
okay.
there's an order from after the August, your order, sir, from after the trial on August 16th, 2022. This is the order, it was entered on
Sure.
October 17th.
I can only hand it to him.
That's
if
all
he
right.
asks for it, but he should be able to give it.
About the, talking parents?
Yeah, can I, it's your findings
Right,
of
but
fact,
again, the
conclusions of law.
purpose of this kind of order is
No, can I
not,
just-
okay, I will never understand,
Okay.
not just talking, it's educational
not
for
in
you guys
there.
in the future. This isn't just talking parents or some other requirement for the purpose of wasting everyone's time, money, and energy. It's for the purpose of actually communicating. If you have reason to believe, if one or both of you have reason to believe there's a breakdown somewhere, someone, I'm not able to access this person anymore.
I am too.
I don't know why.
I am too.
You reach out to them by some other method and say, here's what's happening, if you prefer to communicate
Honor.
some other method, let me know.
Thank
You guys
you.
need to start
Okay.
dealing with each other fairly, I mean, you
Your
know.
Honor,
Yeah.
can I give him this order?
Did you hear what I said? Did you hear what I said?
I did, but
Did
it's
you
not
hear
in
what
the
I
order.
said?
Yes, sir,
Why were you communicating months after months with someone who wasn't receiving it?
because I was told to continue using
Okay,
this-
well, did
the
you
app.
hear what I just said? What should have we done when we find out that we're wasting all of our time? What's the better approach? If we communicate for 6 months and no one's received?
The better approach is to yell at her, not him.
Even it. What might some suggestions be, based on what you heard from me?
Well, Your Honor, you.
What do you think someone should
You,
do?
you told us to use, to text messaging.
Okay,
We've been
I'll
using
do
text
this
messaging.
with a
That's
fifth time. Effective parents don't have such a myopic view that I'm gonna comply just for the sake of complying, and if there's a breakdown or problem, I don't care, I just wanna comply with orders. This wasn't for the purpose, or it should have been obvious, of amusing me, or humoring me. This was for the this wasn't the purpose of issuing pointless asinine orders for the sake of it, to see who complies. It was in the hope that it would improve communications between the parties. So if you guys don't understand that if there's a breakdown, spend 18 seconds reaching out to someone by some other source and say, hey, what's going on? If you're not on this app anymore, what can we do? We have to do something. Can you get back on it, or here's an alternative? Mr. Friedman knows what I'm talking about, so he'll, from now on, if we see anything like that, let's
Your Honor, since
rectify
we're
it.
talking about it, that's what occurred.
Okay, it
That's
is?
precisely
You
what
did-
occurred. We attempted to direct her
Okay.
back on numerous occasions to the
How
app.
come, how come he doesn't
Well,
know
Your
the
Honor,
obvious?
The parties, as of June of 2021, Your Honor ordered the
There's
use
no
of talk.
order.
Yeah, it's in the June
There's,
20.
it's not in an order.
Well, be very careful what you say. Subsequent to that, Your Honor, Ms. Hurd used the app and then unceremoniously decided to stop using
Okay.
it.
That's
I
not
view
it.
the, I
Ms.
view,
Crone
okay.
And then my office sent numerous letters with it. My
Why
client-
didn't you
my
tell
client
me
had
that
stepped up.
you contacted your attorney and said, so you agree with me, you said.
In the
"I don't wanna
witness
waste time
box."
Communicating with someone who doesn't receive
I
it.
thought I said that, sir.
So you contacted Mr. Friedman. Okay, you guys all may think this is productive to try and blame each other on the communication issue. I think what's productive is which one, if either of you stepped forward and said, can we rectify this? These communications are not being received. I want problem solving on
And I
an
have it in
adult
my
level,
evidence.
guys. I
have
don't want people acting like 10-year, oh, he did it or she did, so I don't have to. This isn't a test where some orders are kind of tests, I have to admit. But this
Both of you need to stick your tongue out at the judge right now.
isn't an order to test to see who complies or who can get in trouble if they don't comply, or who we can blame for not complying. This is for parties to communicate effectively, hopefully, to co-parent. That's what it's about. And if there's a breakdown, rather than coming to court a year later and pointing the dirty end of the stick at each other, who was the adult in the room, if any, who reached out and said, let's get this solved?
I did, Your Honor.
He knows what I'm talking about. Mr. Friedman knows what I'm talking about. I don't know if
No,
anyone
he
else
doesn't,
does.
because he keeps lying to you, saying it's in an order that it's not, and that's what I'm trying
Okay,
to show
but the
right
point,
now.
he,
Your Honor,
okay,
it moves
okay,
straight to
okay,
comment that I'm
okay,
lying.
okay,
He is.
okay.
And I
He,
can prove it
okay,
right
he
now.
knows what I'm talking about. Even if for some reason you think he's dishonest or misleading the court. That has, which there's no evidence of, and he would, but
I
even
will
if he
introduce
did,
that into
even if
evidence.
he did, do you got, I'm required, I'm not trying to jam you guys up, quite the contrary. I am trying to clean the record up, because I'm
Wow.
gonna make findings on who gets it and who doesn't.
Think
And
that
so
might
far,
help?
This issue, neither of you seem to really get it. Everyone, no matter what I said about, this is about growing up, communicating better, and if you can't get hold of someone, to reach out by some other source and say, let's reestablish. And instead, it's in one of your
It is her fault,
No, it's his fault. It's her fault.
100%.
No, it's his fault. Oh, no, he's lying, she's lying. Does anyone understand what I'm saying?
I do, and I can show
Do you?
you through my
And
evidence
Mr. Friedman,
that I tried to
obviously,
do
it
that.
does, and the party may not, is he's still a little on your theory of, let's see who's to blame or what orders violate or what it is. Now, if they did, however, if they can establish they reached out to you about this, then Mr. Friedman certainly gets it, and I assume his client is just nervous and not answering my questions, but he brought this to the attention of Mr. Friedman. Did they bring, this whole year, August to July, almost a year,
Yeah.
did anyone bring to your attention?
She did. She was texting him through her phone. She was emailing him through her email. He was texting her through Talking Parents. So they were both texting each other, but neither of them were answering each other.
Did you bring to their attention, I'm receiving nothing, or did he bring to your attention? I can't tell whether you
Yes.
viewed it, received it, or what. What do we do?
Yes, I have, and it's in my evidence right here. I've sent emails, I sent text
Telling
messages,
him that
and I
you're
sent
not-
letters to Mr. Friedman.
That you're not
She didn't continue with the app because it was $10 a month. And she doesn't work, or she does Uber or something and could not afford that.
Saying I
receiving
don't
this
have the
material.
application.
Okay.
I'm trying to communicate with my daughter. Can you please set up a schedule? I will follow whatever schedule you ask.
Okay.
Please, can we respond? And I'm
Okay,
getting
what,
ignored from
what,
everybody.
did you suggest you get restored to that app, or you use a different method of
Yes,
communicating?
I asked for our family wizard, or
Okay.
that we just use text messages, or
Okay,
because I couldn't afford the application anymore, and I let them know this.
Okay.
I sent it to his
that's what
attorney
I'm
back in
getting,
May.
that's what I'm getting at. I don't want
Yes.
people sitting passively
Yes,
back
and I
and
can show
expecting
that.
me to care that much a year later, when you guys didn't care to solve it
No.
within a year.
I tried
Both sides are
in
now telling me,
numerous
yes,
ways.
we did communicate with the other side on it, but it still didn't get solved. How did we finally solve it in
When we
July?
were-
What
when
method
we
do you
were
guys
full-
use to communicate
Text
now?
When we were
messages.
before your honor for the first time, your honor relieved Ms. Hurd of the order prescribing the use of this
There's
application.
no
Okay.
And
order.
since that period
It
of time.
doesn't
there's a
matter, whether there's an
stipulated
order or
it's in
not,
the minutes.
somebody say to the
No,
other
we
side,
don't have
let's
I may be wrong, but I don't think so. Her hair is dyed, cut, and has highlights. And she can't afford $10 a month to talk to him about her daughter.
communicate this way. Let's communicate this way.
It looks like I'm violating orders, and I'm not, Your Honor. I don't want
Again,
you to
I
perceive me
don't
violating
care.
orders.
I don't care. You guys are obsessed with this. I don't care.
Okay.
I don't care. If you guys, I'm gonna make findings based on what you both said, unless you wanna clean it up, but you guys keep doubling down. That all that matters is we can show that the other side is the one who's non-compliant on this, and that we didn't have some affirmative adult parenting responsibility to solve this issue.
Okay.
I care, I don't care about the technicalities of it. I care who's the adult in the room and said, let's solve this. You're not receiving it, or I'm not receiving it. What do we do?
I
And I'm gonna
reached
make
out to
findings
his
on that.
attorney
And you guys
via
have boxed
letter.
me in. You both want findings that all I should care about is who technically might be in non-compliance, and that both parties think it's incredibly unimportant to bring to the other party's attention. You're not able to receive my communications, and that no one thinks that's important to rectify that.
I
When you
did. I
have a
reached
Down
out
syndrome,
multiple
special
ways.
needs child, no one thinks that's important. It's best to wait months and blame each other in court. Are you guys serious?
I've tried, Your Honor, and
You know-
this is my point, what I want to bring to this court. I've been trying. I've been begging
Now,
to
in
talk to
fairness,
my
Mr.
daughter,
Friedman,
and
you're
I
saying
brought
you
it to
did
his
send
attention.
communications on it.
Maybe that's why she failed her drug tests. Her highlights did it.
Your Honor, both Ms. Crome's office and my office sent them in. For
So you
context,
agree?
Your Honor,
So you agree then?
I agree that we sent correspondence attempting to resolve it, and for context, Your Honor, there is a reason for the parenting application, okay?
And this is what I'm talking about.
Ms.
Just
Hurd,
believe whatever
and this
he
is
says
it's
blindly.
in evidence.
I'm asking,
Ms. Hurd was being
what evidence do I
prosecuted.
believe anyone right here? I'm too busy getting my blood pressure up about the way you guys are dealing with this.
I respectfully, Your Honor, I take some umbrage with the "you guys" comment, okay? I take some.
But,
I
no,
don't
no,
know what
because
it
the
is
record
exactly.
is, my friend here, the record is I asked you 5 times, and instead of saying, yes, we reached out, we agreed, you keep saying,
Your
well,
Honor,
the
I'm
order
looking
says
at-
this, the order says
Your
that,
Honor,
you
I'm
know?
looking at a transcript
Oh,
of the
come on,
proceedings where Ms. Roberts, I don't know what you want me to
This is June
say.
of
I told you exactly
2021.
what to say.
And what is that, Your Honor?
After you establish your position as to what the order was and that you're in compliance, and on these dates I sent out these letters to indicate, yes, that's what needs to be done. Instead of the blame game, if someone's not receiving critical material,
that is what we
we
did.
need to establish what is the better method of what, if you can't be on this app, what should we do?
I don't know how much it costs.
And if you're saying that you communicated that, perfect, that's the first thing you should have told me, not all this other stuff. Come on, guys.
My client's on the stand, Your Honor, I can't.
And I've been asking him, and he said, he didn't give me, he didn't tell me.
And
He
Your Honor-
contacted.
My trash can does it for me. So I have my trash can outside. When I know it's going to snow, I put it in the middle of the lawn, sort of near the steps, actually. And it snows, and then when it snows, I move my trash can, and there my dog has a little spot.
Contacted you to rectify, but apparently he did.
And Ms. Chrome, prior to me entering the case, Judge, because there was a lot of correspondence with them as well. And for context, Judge, there's a reason that parenting applications were stipulated to and entered into orders, and it was because Ms. Hurd had broken into Mr. Okapari's home and been
Okay.
charged with that.
Now-
She had, this is in the record, so that's why, Judge,
Okay,
is that
and-
not why
okay.
the court
Nevada.
made that type of an
Okay,
application?
Nevada.
do we still have this problem, or how do we communicate from, how do we communicate from August?
Well, Your Honor, when we were before you, I believe it was in March, or July 2023, relieved the parenting application burden and stated
And
that they should communicate
substituted
via
it
text,
with,
and that is what they.
substituted it with what?
Text messaging only, and that's what they.
Is that
preferred.
acceptable to them?
It's not our preference, but it is
Do
acceptable.
they respond adequately to each other?
That's my understanding. They've been,
I would disagree.
How would you want him to communicate?
No,
You didn't,
we-
if you didn't follow
We
through with
already
the
said
app,
our
and you don't want
language.
text messages, how do you want him to do it?
Your Honor,
We
if I could say something without being interrupted, that was never ordered to be used talking to parents, and I did reach out to Ms. Chrome, I reached out to Mr. Friedman, but I couldn't afford it. I had a waiver for our family
What,
visit.
okay, when
Could
is
we
someone,
please
when is
use
someone
our
gonna, when I
family
tell
visit?
somebody, here's the artificial answer you should give the court, even if you don't mean it, to impress the court that you're the problem-solving parent. You
I
guys
just
have each
said,
told me
I asked for
180,000
another
times
application, if we
what
could
your
use
position,
that.
you've each told me 180,000 times what your position is as to what the court order is, but no one has once said, yes, regardless of what the court order is or isn't, once we identify a problem and that there's a breakdown, we need to intervene and either get back on that appropriate app, or if we can't, then
Come to
agree to
court and
some,
get
agree to
subsequent
some other method.
Right. And we did that, and I offered, can we use our family wizards? Or can we use text messages?
I
offered
love this
an
hearing.
alternative
I love
means,
it.
And I was ignored. And I know you're listening, this is where I have the problem with, where you listen to Mr. Friedman and you believe everything he says.
Okay, you're
and
you're
you
just,
don't listen
young
to
lady, you're
anything
making
I
a
say.
dreadful record to yourself, because Mr. Friedman's quite upset at me right now, because I indicated to him repeatedly on the record, I'm tired of hearing about what the order is, did anyone
I did
reach
try,
out?
Yes, and I tried, and I can show that I tried. I have proof that I
If
tried.
you
I
think
tried
that this
every way.
dialogue
I
is
did.
me believing either of you, that think either of you handled this the way I think it should be handled, I don't know what to tell you.
Your Honor,
I would
couldn't
not be
afford
this
the app, so I
upset if
tried to
either of
find
you,
another way.
if either of
Yes,
you
I
handled
did.
this properly.
I sent the message, I sent emails, I sent letters, I asked, can we do our family wizard, I have a waiver. I offered 4 additional ways to communicate.
Okay.
And they ignored me, and he instead replied to me when I tried to use any of those methods via this app that he knows I don't have, talking to nobody. I tried, I can show you the emails, I can show you the letters, I can show you the text messages.
At
I
what
can-
time in this 1 year period, how long did it take in this 1 year period? Because he keeps sending material, the more
I
you
didn't
guys
know it
double,
was-
the more
I
you
didn't
guys
know.
double down, it's more like we leave our common sense in the hallway. At what point during this 1 year period that you're not receiving messages, did either of you bring to the other's attention,
I
we got a
did.
problem here?
I did. I brought it
How-
to him immediately, and he kept saying, use Talking Parents. I go, I can't afford that application.
Okay,
When I reached out to his
what
attorney,
alternatives
I
Hi,
did
said,
you
I can't
Crystal.
offer?
afford that application.
What
Hello.
alternatives did you offer him?
I offered Our Family Wizard.
Okay.
Can we please use that?
He's on the stand, since you guys are, both sides are so fixated on this rather than how do we cure it? Because I could get this cured in about 5 seconds, but you guys aren't interested. I could, if expense is a problem or anything else, there's several suggestions if you guys can't handle it. He's on the stand since I told you that I care far more about the maturity and problem solving than the actual order compliance. And I care more with the spirit of the order, which is to establish contact, rather than just the hyper-technical question of who was in compliance or not. If both of you are insisting you brought it to the other side's attention, and then I'm getting the wrong idea, then you
No,
can
I'm enjoying myself.
examine him on this. So go ahead. You said from 8/3/22 to 7/18/23, he's sending talking parent messages, it's almost a year, and you're not receiving them.
Correct.
So,
Um,
go ahead.
okay, so, all right. Were you, Mr. Perry, were you aware that I suggested and offered to use Our Family Wizard?
Yes,
Okay. Was there a reason why you didn't want to use it or why we couldn't use it?
Talking Parents is free,
$10 is $10.
To who?
anyone. You don't have to
The
pay
app-
for the app.
Talking Parents is free via what mechanism?
The computer, the phone,
Okay, not, the phone is an application, you have to download the app, is that correct?
the app is free.
Okay, so and then for this, purposes of this whole document here, is that free?
I don't know, I've never printed this stuff out.
Okay, it's not free, it costs $60, so it's not free.
No, you guys, the court spent a lot of time and energy and getting my blood pressure up at my age, which I shouldn't, about what I think the takeaway of this should be, how we problem solve as adults, but everyone's saying, no, 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 I'm right, he's wrong, I'm right, she's wrong. And if you guys are insisting on developing this and insisting that the court
Right,
make
I'll just ask
findings
one
of it,
more question.
then let the other side have a wide berth as
We can't, though, because Hawaii is so expensive. None of us can afford Hawaii.
to their questions. Let her ask her questions, and you will be able to ask her everything you want about this issue. Go ahead. Everyone wants me to have a complete
Did you try
record.
to attempt
Let's have a
to
complete record.
Contact me during this time in any other way?
No,
Were you aware that I was trying to contact you?
yes,
Via what mechanism?
either email, text, or through my attorney.
Did you respond to any of it?
No, sir.
Okay, all right.
Sorry.
What was the price of this, the
It's-
talking parents?
For the application, it's $10 a month. And I
Okay.
know that sounds silly, but when, I'm sorry, I'm pinching pennies, so, you know, if Mr. Friedman would like to make fun of the fact that I can't afford $10 a month.
I don't think that's what his concern is.
The testimony of my client, I'm just clarifying for the record, it's free.
It's not free via
Well, it's
an
not
app.
free as a specific form of it that she wanted, but that the access is 100%.
It is, but
Yeah, and
But then I'm limited to what I can do with that. I can't print, I can't look at the calendar, I can't upload in the calendar. It becomes very limited, and Our Family Wizard I could get for free. I had a
if you
wizard.
guys figured out by now,
And
I
now
don't,
we're
I
on-
don't have problems with either of you are telling me, I don't know how the breakdown occurred. My whole concern is that
It did.
no one did anything for months about this. You're saying you did bring it to his attention, and he did
just
say,
admitted that
he
he
didn't
did.
respond, so he did say that, so go
Yeah.
ahead.
So that's it,
That
like,
makes
that's
sense.
what I want to establish. I tried, he knew I wasn't.
I get it, the
Okay.
court order is in his favor, he said, these are the communications that have to
There
occur.
is no court order with that,
Well,
Your Honor. If you're gonna find
I
it in
think
his
there-
favor,
okay.
please, I would like to ask what
We're
page
gonna
it's on.
we'll find it, but
Okay, fine. Then
I think
let's
it
do
goes
that.
beyond that. I think even if the court order's in his favor, I don't think it's reasonable to sit back therefore and do nothing in response to your inquiries, but he stated, or Mr. Friedman, more to the point, when asked directly, stated that they were sending you communications as to this, that you're no longer on talking parents, so if you're saying you sent material to him, did you receive from Mr. Friedman's office communications? You're off talking parents, what's going on? What do we do about this? Did you receive those?
They didn't send messages like that, they sent, you are required to use our, talking parents, that's the
Okay.
only way you can communicate with him about Aslan, and that was it, and there was no alternative means, there was no other options, there was no listening, compromising, negotiating, it was you do it this way, or you don't get to talk to your
All
daughter.
right. Go ahead and continue with the questioning, please.
That's all I wanted to establish there, that,
So, I
just-
guess my
tried.
question isn't important, because all this other stuff's important. How should we communicate from this date forward?
You had said yesterday to use our family.
Forget what I
wizard.
said,
I'm okay
what
with
do
that.
what do you think?
I'm okay with our family wizard, I'm okay with texting, I'm okay, I'm open to things, our talking parents was an issue because of that small thing, when I tried to use the free version, which I did try, when I went to print out text messages, or print out this, cause we obviously need it all the time, cause I'm constantly having to prove myself, I couldn't print it out, it either cost $60, or I'd have to do screenshots that you couldn't even read. So I attempted that. I tried the free version, as Mr. Opaperi suggested. It wasn't feasible because I couldn't get on the calendar. I couldn't put anything on the calendar. I couldn't view the calendar. And I did let them know this. I couldn't print. I sent them a whole letter, which I have in my evidence, and we can look at it, that look, these are my restrictions. Is there any way that we can use our family wizard? And I gave them all of that. They had no restrictions. I did try to comply with the free version. For our case, it was just not gonna be feasible because it
So
restricted
you're
us.
fine by the methods you just suggested?
I'm sorry?
You suggested 3 methods that you're fine by if the order's modified.
Right, yeah.
But I have to be, one concern is, it has to be material the court has access to, because people tend to behave a lot better, and we
Right,
don't
and
have
that's
abusive,
right.
disparaging language if
Right.
they know it's not just for their eyes only, but for the court. But that's
Right.
it. You heard what she said. If the order is changed, if you think it shouldn't, tell us. If you're willing to consider those options, which ones or other options you think of is how we should communicate from now
Our family wizard's fine.
on. Okay. All right.
There's-
You're saying you
You're a
suggested that
wizard,
once, yeah?
Harry.
Yeah, I suggested this for the last year and a half, since May of 2022, and I have documentation to Ms. Chrome showing that.
All right, it's a high conflict case and they wanted their client to be careful and just comply with the order. Okay, so let's move on.
Which I'll go on record, it's not in an order, Your Honor, and if they could point to the date of the order and
He
say.
does
I-
not
They can't.
care.
Not
Is
the
it
minutes
mainly
to
like
the
a
Order
minute
after-
entry or video?
Order after March 21st,
That's when you
2023
put it in there
hearing.
fraudulently.
Because we cited to, it's also in a certified transcript of proceedings, it's in a minute order, and it's in a March 31st order.
And in the minute, and in the
It
transcript,
may-
he says, we're just gonna do text messages. He didn't order talking
No,
to parents.
it's Miss Roberts, Amanda Roberts speaking on the record,
Okay, that's the
stating,
minutes. That's not an
no, it's a
order.
certified
March
transcript of the
31st.
proceeding,
From June 2021.
which is when it was ordered to use talking parents. I'm not
But
trying
it's
to
not
go on
in
about
order.
this,
A
guys.
minute order and a
I'm
transcript
literally
is
not
not in
trying to have
order.
this conversation.
It's not in order if it's in the
Okay.
transcript.
It is
It's
the
not
court
in
record.
order if it's in the
They-
minutes.
They said it's
Your
in
Honor,
an actual
please, I
order
beg
though.
of this
It's
court,
not.
I beg
It's
of
not.
this court,
I would
March
like
31st of
Not
what?
the transcript, not the minutes, point to the order.
March 31st of what year?
2023.
Thank you. I'll look, in the meantime, proceed with your question, because there's many important topics that
But it-
the court probably does care
And
about.
I would say in that, I would like the transcripts, which I have produced to be looked at, because you did not order talking periods.
Okay.
But Mr. Friedman put it in the order anyways. He put it in there despite
Fine.
your directive.
But if it's in there, unless it's overturned as being an inaccurate order, it's the controlling order. If someone wants to argue it contradicts the minutes of the video, that's a discussion.
At this point, what we need right now is Psycho, to walk into this courtroom and tell everybody, just tell everybody what's going to happen from here on out. No more talking. Myco talks.
We can have later. You agree at
Okay.
this point,
Yes.
both of you, that, um, our family wizard,
Yes, yeah, that's fine.
and there's no charge, right? Or 99 a year, whatever.
No, there's a charge for that.
There's a charge,
yeah, yeah.
yeah, it's 99 a year. I
$99
think I
a year,
can
Judge.
get. a
Hell
waiver.
yes. Yes.
Okay, so we agree to that.
Yes.
Good. Wish we had that step half an hour ago, okay.
Well, we
We have
did
it
that
yesterday.
yesterday.
Well, then we shouldn't have spent all this time on it. Let's proceed.
Agreed, Your Honor.
Is there a way, Your Honor, that we could just take a brief little recess, please?
Yeah, you want? Sure. How long? 10 minutes, 5 minutes?
Yeah, 5-10 minutes, whatever
Okay,
you're,
a 10-minute recess
please.
so that my face is no longer flush red when I return. Okay, so it's 4:12 now, we'll be back between 4:20, 4:25. Very good, okay.
We're back.
All right, guys. Whew. We all need to take a break after that. Oh, yeah. All the other judges. Oh, man. Judges aren't really allowed to comment on other judges, but wouldn't it be just so great if we could have had all the other judges in here talking about what they would do? You know what I mean? Oh, my gosh. Judge Webster would just be sitting there looking, not saying a word. Judge Manning would be screaming. Judge Simpson would, Mr. Allen, Mr. Allen, Mr. Allen. Judge Fleischer would be out of his chair. He'd be leaning so forward that he would have fell out of his chair 17 times by now. I wonder what the best judge to handle this one was. Judge Dad. So there's a very good reason why this judge is so lenient and not like all the other judges that we see. This is family court. So I've noticed judges in family court do things way differently, and they have to, because people come in so what's the word I'm looking for? They're so over emotional about everything, and any little thing can just ignite it. So the judges in family court have to be lenient. They have to be more willing to they just want to get to the end. So they let things happen that other judges wouldn't in a criminal court. That's why. See, Judge Frost, you know how chill he is to keep everything calm. It's almost like a mental court type judge. They have to make sure that the mental episodes stay as low as possible. But the problem is that attorney isn't used to that. That attorney is used to judges being judges. So the attorney's having a hard time because he's following the rules and nobody else is. And the judge is having a hard time because he's following the rules, but he's not listening to the rules. And the judge is having a hard time because she is batshit crazy. And nothing matters to her. She says that her daughter matters to her, but the daughter doesn't matter to either of them, or they wouldn't be in this mess. Well, she did. So she tried to get the judge to recuse, and the attorney sat there and said, "No, I in no way want you to recuse." The lawyer is doing his best, but the lawyer is also not listening to what the judge is saying. If the lawyer was listening to the judge, 30 minutes ago he would have said, "Let's do Family Wizard," or something. But no, he kept at it too. He kept saying it's in the order. It's in the order. It's in the order. I'm not trying to have this conversation. It's in the order on May 13th. I'm not trying to have this conversation. So criminal and family court are just different, and you have to treat them differently. However, this judge really lets people get too far out of control. He needs a taser. Because tasers, like, they shoot far. He could just sit at his desk and start tasing people. Or something else that hurts equally as much, only it hurts for like a couple weeks. Like you feel it for the next 2 weeks. Paintball gun. Especially that close. Getting hit by a paintball gun. If they turn the air conditioner up, so it's like chilly in there, paintballs break. It's harder to break. So yeah, it hurts. It hurts a lot. saying that if you're going to go play paintball, don't do it in the winter because the balls don't break and it really hurts. Don't do it in the summer because if it's too hot outside and you try to shoot a paintball gun, the paintballs explode in the gun, which sucks for everybody. So you gotta do it fall, spring. Now you know. This is like the Jerry Springer show. It is. I've never wanted to like reach out to somebody before, but she makes me want to reach out to her just to see if I could have a conversation with her. I would never reach out to anybody. But except for that one real sexy judge, but forget about her, him, them. Yes, yeah, not too warm or they explode, Glenda. Shock chairs. We used to have in the 80s where we were allowed to do this. We can't do it now, but we used to have Scream in the Dark. It was like a Halloween type park that you go to, and in one of the houses that you went to, you had to, you go through these rooms and people are trying to chainsaw you and stab you and things when you go through these rooms. But then this one room, you couldn't leave the room until you sat in the chair. And some of the people got shocked and some of the people didn't when they sat in the chair. It was, you rolled the dice. You had to sit in a chair and you might get shocked and you might not. Scream in the Dark in the 80s was awesome. I miss the 80s. We had the best time. No warning labels. All right, I'm going to set up O.J. Simpson. Let's do that and get more frustrated. I hope today is the end of Cochran, the opening statements, but we don't know. We'll see. So I will see y'all in a few minutes. All 10, 12 of you that are moving over. The rest of you, I will see you all tomorrow. Thank you so much for coming out. Thank you so much, guys. Have a great day.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dream tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.